All right, the next case on the docket, Collection and Recovery of Assets, Inc. versus Patel et al. Okay. Go ahead.
May I proceed?
Yes, sir.
Good morning, Your Honors. My name is Stephen Biggie. I'm from the firm of Arcadia, Biggie & Wood, and I represent the appellant in this case, Collection and Recovery of Assets. I'd like to reserve 5 minutes for rebuttal.
You got it.
Thank you. I'd like to start off by raising the two most important issues is the legal requirements for setting aside a judgment and the equitable requirements for setting aside a judgment. And the legal requirements that we're here to argue or here to discuss today are what were outlined in Weitzman and what were outlined in Gotham Insurance. In particular, the Weitzman case found that enforcement of the judgment was penalizing a victim and rewarding a wrongdoer.
You think it's equitable for a co-guarantor to avoid their proportionate share of liability by purchasing the judgment? Is that equitable?
I do not think that is equitable, but that is not what has happened in this case, Your Honor. And that's never been our position that Dr. Chandra or Dr. Chandra's estate is avoiding payment on this judgment. That has never been our position.
So your position is that, well, their obligation, their remedy is to get a lawsuit, is to sue for contribution.
That is correct. That is...
Well, you know, the difference between owing a debt and having to sue to recover that debt are very, very different, aren't they? How many judgments are out there that are not collectible? And why should he be able to use this artifice to give them a lawsuit?
Your Honor, it's not a situation where there's an artifice. This has been a long-standing dispute between two business partners where there's money on both sides. This is not a situation where...
Well, we have no idea what the estate, how the estate's set up, and you know, he's deceased, so now they've got to go against the estate, which makes it even more difficult.
That's correct, Your Honor, but the issue really is that this was not set up to frustrate collection attempts or to frustrate Dr. Patel. The reason that this was set up was because that there was a foreclosure action that needed to be dealt with. And in this particular situation, Dr. Chandra is the 75% owner of the holding company that owns the property that's being foreclosed on. Dr. Patel is a 25% owner. There's been no payment on this note whatsoever from Dr. Patel. So this entire burden of this debt is falling on Dr. Chandra. So in order to protect himself, he creates this company and purchases the judgment from Wells Fargo. So now he's in control of the foreclosure action, and he could manage this foreclosure action and manage this liability while there's all these additional lawsuits ongoing that Dr. Patel is continually filing against Dr. Chandra.
By manage, do you mean seek to collect the entire judgment from Dr. Patel?
Yes. Not only can he, well, we need to kind of separate between the two because...
Well, didn't the trial court necessarily find that Dr. Chandra and CRA were alter egos?
No. The court was of the position that, and I don't think the court could find that they were alter egos at the time. At the time of the hearing, Dr. Chandra was deceased. He's no longer an owner of the company. He's no longer in control of the company.
But at the time it was formed, he was the 100% owner.
That's correct. That was his testimony in his deposition, that he was the 100% owner at the time it was formed. However, over the course of the 4 years, while this judgment was final, while Dr. Patel was enjoying the benefit of not paying and not having the property foreclosed on, Dr. Chandra still has to pay to upkeep, maintain this property. It's not a situation where...
Yeah, but Dr. Chandra could have let it go into foreclosure.
He could have let it go into foreclosure, but then that's an extreme loss for him. That's an extreme damage for him. It's a loss and a damage because when it enters into foreclosure, not only does he have to pay the judgment, he has to pay the attorney's fees from Wells Fargo, he has to pay the interest on the mortgage, he has to pay the interest on the judgment, and all the court costs associated with Wells Fargo having to go through that foreclosure. So in that scenario, he's paying and Patel is paying significantly more than if he creates the company and then goes and purchases the judgment himself. And that's what keeps the property out of foreclosure and allows him to manage that case and manage that property while all these other ongoing cases between what Dr. Patel has filed against him.
Do I understand the appellant's argument to be that the court shouldn't have used its equitable powers to limit the judgment here because Dr. Patel had a remedy at law to seek contribution?
100%, yes.
Okay. But in the trial court, you argued that if Dr. Patel tried to seek contribution, that would have been entirely set off, correct?
I'm not saying it could be entirely set off. I'm saying that is a defense that is never going to be probed or looked at or could be argued at that particular time because the judgment is just automatically cut in half just because the trial court believes it's unfair for a co-debtor or a co-guarantor to set up a company, purchase the judgment.
Well, I'm going to read a statement from page 8 of your opposition to their motion to limit the judgment and tell me how it's an abuse of discretion for the court to invoke its equitable powers. This is the next to last paragraph. The real reason the judgment debtor will not file a contribution action is because he is so overwhelmingly indebted to Dr. Chandra, now the estate of Dr. Chandra, and their former companies for failing to make capital contributions, that any claim for contribution would be reduced to zero by set-off.
That's correct. That is correct.
So you're saying he has no real remedy in contribution?
I'm not saying he doesn't have a remedy in contribution. He could file a claim for contribution. There's all these other factors, self-inflicted wounds by Dr. Patel on himself that make his contribution action a poor contribution action. I'm not saying he can't file for one. I'm not saying he's not legally entitled to file for one. He can file for one. However, based on all his poor choices in filing multiple lawsuits against Dr. Chandra, being unsuccessful, not contributing to the mortgage, not contributing to the cost and upkeep of the property for multiple years, that there's a substantial amount of debt that he owes to Dr. Chandra or those particular companies and businesses that they've had together that makes his contribution claim that he legally has a right to very poor. So we don't get a chance to calculate that or use that $90,000 in that ultimate determination because it's automatically been set aside because the court thought it was inequitable for a collection and recovery of assets to attempt to collect 100% of the debt against Dr. Patel. So there's all these particular additional issues that are automatically wiped away, wiped aside, just because the court decided or thought it was fair and equitable to do basically a splitting of the baby on the judgment and just cutting it by 50%. So there's all these additional arguments and all these additional monies owed that we lose on this particular issue because the court just automatically cuts it in half.
Well, but if your causes of action were that good against Patel, you could have just gone ahead and pursued those and gotten judgments on those.
It's not really, I understand the court's position that collection and recovery of assets could file claims, but those claims are really filed as counterclaims in lawsuits that Dr. Patel has brought. There was the first lawsuit, there were counterclaims.
So what? So what? So they're counterclaims. If you've got good claims, you pursue those claims. That was an option available, correct?
It is an option available, correct, Your Honor, but it is us taking our legal option. It's not us asking for this extraordinary remedy 5 years after a judgment was entered and having the judgment amended or cut in half, which is an extraordinary remedy that
Well, but that's what the guarantee called for. The guarantee is that each side guaranteed half of the mortgage.
Well, there's more individuals on that note than just the two. There's the company itself, there's Dr. Chandra, there's Dr. Gaydon, and there's Dr. Patel. So there's multiple people.
How many people were on the guarantee?
There's three, Gaydon, Patel, and Chandra. And then there was the actual entity itself, ZETA Medical. So there are...
And who owns that?
ZETA Medical is, it's disputed who owns what, but the percentages are disputed, but it's essentially Dr. Chandra, Dr. Patel, Dr. Gaydon was a part owner, and Dr. Patel's wife is also a part owner. So there are also multiple people involved with that company. But as far as, in particular, along with the note, in this particular case, it would be Chandra, Gaydon, Patel, and the ZETA Medical would be the companies that are ultimately, or the individuals ultimately responsible for payment.
By the time it got to foreclosure, hadn't Dr. Chandra acquired the other doctor's interest?
That is correct, okay. Yes. He did acquire the other doctor's interest by the time it was in foreclosure, that is correct.
Okay, so that is as it goes in terms of the guarantee. At that point in time, what were the percentages on the guarantee?
There are no percentages on the guarantee. You're talking about, I'm sorry, I understand your question, I'm sorry, I misunderstood your question. The guarantee for the co-guarantors, it would be a third for Patel, Gaydon, and Chandra. They're all co-guarantors on that particular note. Because the guarantee is not from the operating agreement. We could talk about ownership interest in the company, but the guarantee is not because they're owners or shareholders in the company. The guarantee is because that is the promissory note they signed with Wells Fargo, who the judgment was initially acquired from. But that's where the guarantee comes from. It's from that initial promissory note that was included when the cases were filed. I believe there were multiple notes, and they were renewed a few times because they were due to accelerate after a couple of years, but they were renewed a few times. But that's where the guarantee comes from, the actual note itself.
So moving to the subsection of the rule that's used here in 1.540B5, it simply says where it's no longer equitable for the judgment to have prospective effect. And the Weitzman case is discussed quite a bit, and there's simply doesn't seem to be a lot of case law on 1.540B5. Is it your argument that Weitzman somehow limited that rule to only equitable cases involving fraud?
No, there's two, when we're talking about like the legal reasons and the equitable reasons, there's two legal reasons that, based on the research, that kind of stick out. One is a substantial change in circumstance, and the other one was Weitzman, where it said, enforcement of the judgment is no longer conscionable because we're rewarding a wrongdoer and punishing a victim. And so when we look at this case, when they filed their initial motions, their entire argument was that there was a fraud committed, that there was money taken from this company, that Dr. Chandra was the wrongdoer, that Collections and Recovery was the wrongdoer, and that there was fraud. So when you look at those allegations, and you look at the first case that was filed that made the identical allegations, that was dismissed at summary judgment and affirmed on appeal, you don't have what happened in Weitzman. You do not have here. And the judge specifically found there's no fraud, there's no misconduct. The collection and recovery of assets was not created for any fraudulent reason. It was created for a reasonable reason. So Weitzman doesn't apply. You throw it out. And then when you go to Gotham Insurance, we talk about what is a substantial change in circumstance. And the argument of the appellee is that there was the purchase of the judgment. But it's not a substantial change in circumstance because he wasn't paying when Wells Fargo had it. He wasn't paying when Collection had it. His position has always been the same. I'm not going to pay it. It wasn't until that his property actually was levied that this was filed 4 years later. And I don't think, it's not a substantial change in circumstance because no matter what happened, Dr. Patel wasn't going to pay it. And even when he was forced to pay it, whether it was forced to pay it to Wells Fargo, whether he was forced to pay it to Collection and Recovery of Assets, he would always have the legal remedy of contribution. That would always be his legal remedy. So his circumstances never changed, even when the judge...
I keep getting back to the point. You argued in the trial court, which I'm just going to accept as true, that if he filed for contribution, it would be reduced to zero. So he has no relief through contribution. That was your own argument.
Well, even if he has zero, if he's in a position where he's so indebted to Dr. Chandra, then he shouldn't even, he should be paying the 90. He should be paying the 90 if he's indebted to Dr. Chandra, because essentially, let's even.
Well, isn't that what the trial court essentially ruled? He's only going to be paying the 90, his half.
Well, I'm sorry. When I'm saying 90, I mean the second 90. It was what I was referring to. That he should be paying the full amount because the company itself is who's owed the money, not Dr. Chandra. The company is owed the money. The company is a separate legal entity. The company itself never committed fraud or any misconduct against Dr. Patel. And when you look at the legal remedy, contribution, that's fine. That's his legal remedy. He should file it. He should pursue it. And then, whatever happens afterwards, happens after all the facts are fleshed out. But essentially, we have to go down the legal path, the legal obligations that are there in front of everyone, not cut a judgment in half, 4 years after the fact, only because they don't like the fact that a piece of property was finally levied.
Well, you're into your rebuttal time.
I'll reserve the remainder for rebuttal.
May it please the court, I am Jim Talley. I represent the appellee BACHU Patel. The issue before this court we submit is very straightforward, and that is, did Judge Rainwater abuse her discretion in granting the relief to Dr. Patel under Rule 1.540B? Now, we know from Kanakaris, I can never pronounce that name correctly, that the Florida Supreme Court has said, well, what does abuse of discretion mean? It means a trial judge acted arbitrarily, or that the trial judge acted fanciful, or acted unreasonable, or stated in a different way. Is the discretion exercised by this trial court resulting in a decision that no other reasonable person can agree with? Now, we do not have any binding precedent.
You would agree that's extraordinary relief.
It is extraordinary relief, yes. It is. We would submit the very type of relief that rule was entitled or was designed to grant. I would argue, number one, this can't be arbitrary. Judge Rainwater conducted an evidentiary hearing. When the hearing started, she indicated she had read the moving papers. During the opening statements, she asked meaningful questions of counsel. She took the evidence. In closing statements, she asked meaningful questions, and she articulated the reasons for her ruling. We would submit that is the absolute archetype of the judicial method. There was nothing arbitrary about her approach. Was it fanciful? Well, the relief may have been extraordinary, but it was not made up. It was relief specifically authorized by Rule 1.540. So we would submit that it cannot be deemed fanciful. Was it unreasonable? I think Your Honors have recognized that there is a uniform, recognized rule of the relationship among co-guarantors, and that among themselves, there should be proportionate liability. I think we have shown in the cases, not only in Florida, and I would remind the court of Curtis v. Chacon, where the purchasers of the guarantee were a husband and wife when the wife was not one of the guarantors. And our courts have said you cannot, under that arrangement, try to evade your liability under the guarantees and force all of the liability under the other guarantors.
So how is it a substantial change in circumstance that this corporation, albeit related to Dr. Chandra, purchased the debt, and now it's simply another organization other than Wells Fargo pursuing the debt?
Well, I think the change is actually that it was the purchase of the note, effectively, of a co-guarantor. And once that happened, the case law is uniform that that cannot rearrange the relationship among the co-guarantors. So the question, I suppose, is, was the creation of a single shareholder corporation by one co-guarantor to purchase this note and mortgage sufficient to rearrange the relationships among the co-guarantors? We would submit that the law is that no. Now, I don't have a specific case where a corporation purchased a note and mortgage, but we have situations where husband and wives, where you have estates doing this, where we have some attempt to get around the general rule, and the courts have uniformly said no. What is most interesting is there's not a single case offered to you which sustains the very technique attempted here. Nowhere. There has been no instance where the appellant can say, yes, here is where an assignee is free to rearrange the relationship among the co-guarantors. We believe that is telling on the reasonableness standard.
Although it's not cited in the order we're reviewing, did the judge have to find that CRA and Dr. Chandra were alter egos?
We don't believe so, Your Honor. I think the mere fact that he formed this corporation as a 100% shareholder with the sole intent of purchasing this note and mortgage was sufficient. At that point, there's no other business purpose announced in the record for this entity. It is clear in the record that the intent of the entity in purchasing this was for Dr. Chandra to receive benefit, and there is no dispute in the record that this corporation formed by this co-guarantor has sought to collect 100% of the debt only from Dr. Patel. And let's look at this from a flip side. If you believed that collection and recovery of assets was an arm's length purchaser of this note and mortgage, then why didn't it go ahead and proceed with the foreclosure against real property, which had a value far in excess of the amount of the judgment? Why didn't collection and recovery of assets attempt to pursue a Dr. Chandra for the collection on the guarantor? And I think Mr. Biggie told you why. This whole thing was to try and protect Dr. Chandra because he owned a majority interest in the mortgaged property, and the intent from the get-go was to force 100%, for whatever reason, of the obligation on Dr. Patel. Now, you may disagree with how Judge Rainwater weighed those equities, but I don't think you can say there is no reasonable person that wouldn't agree with her.
Counsel, they've raised the argument that there was a legal remedy for Dr. Patel, that you didn't necessarily have to go to this extraordinary relief in equity, that there was a legal remedy and that he could have sought contribution after the fact. Why do you think that that is not a valid argument?
Well, first of all, it doesn't fit with what was actually happening. Okay, so Dr. Patel never paid 100% of the judgment. So there never was a contribution right in his favor. In March of 2017, there was a writ of execution issued, and Dr. Patel immediately, it was our first entry into the case, in July of 2017, sought relief from enforcement of the judgment against him. So there never arose a legal right of contribution because Dr. Patel never paid 100% of the note. Now, had it been collected from him, had the judge not found the equities in this situation, and 100% was collected, which hasn't happened, then he presumably would have a contribution right. But that right never arose under the facts as they exist as we stand here today. Your Honors, we would respectfully submit that based upon the specific issue before you, which is, did Judge Rainwater abuse her discretion? There are no facts in this record upon which such a finding could be made by you, and we respectfully ask that the judgment be affirmed. Thank you.
sir.
May I proceed?
Yes, sir.
The biggest issue with opposing counsel's argument that this was a nefarious plot is the fact that Patel stipulated to the substitution. They never opposed it. They were okay with it. They were okay with having the benefit of preserving the property and not paying. In addition to that, there's no nefarious...
What legal argument could he have made in opposition? At that point, the note's been sold. That's a transaction between Wells Fargo and Patel. What legal argument can you make?
If he had an issue with the judgment, he thought it was inappropriate, unfair, that would have been the time to file his motion for relief from the judgment. Because when we go back to, when they finally made the argument in 2017, they weren't asking for half. They were asking for the whole thing to be tossed out.
But Patel has no way to undo the transaction between the corporation and Wells Fargo.
That's correct. His form of, if he had an issue with the transaction at that time, that would have been the time for him to oppose and say that there's a legal issue with it, with collections. There's an issue with the judgment. We're talking about all these issues about.
Well, there are potential issues.
Potential issues.
Yeah, but none that existed at that point in time until Patel tries to collect.
I think the same issues existed for Dr. Patel when the judgment was acquired versus today. Because even after the judgment was acquired, there was still discovery.
Really, Chandra tries to collect.
When collection and recovery of assets was trying to collect, it was trying to collect immediately after it acquired the judgment. There was discovery done, interrogatories sent, requests for production sent within the year of that judgment being acquired. And it was not until the actual property was located and attached when this motion for relief was filed.
Right, but are you suggesting that they're barred by some sort of time limitation?
Yes, the statute itself has, the rule itself has a time limitation. We're talking about the 1-year limitation for fraud. They need to pierce the corporate.
But haven't we rendered an opinion that said there was no limitation?
I think the judge at the trial court was incorrect when she found that there was no limitation, because the entire argument that was made at the lower court revolved around fraud. That both the motions for relief talked about fraud. In order to pierce the corporate veil, you have to prove fraud, either reverse pierce or forward pierce. You have to prove fraud. The judge considered fraud when she was making her ruling. Fraud was an argument made throughout.
But since this was resolved under subsection 5, there is no time limitation on that, correct?
I don't think it was properly ruled under subsection 5. I think the proper subsection was 1, or the fraud section, because they made fraud arguments throughout. The judge considered fraud throughout. They need to prove fraud in order to pierce the corporate veil, in order to show that collection and recovery and Dr. Chandra are alter egos. They need to prove fraud. So fraud was throughout the entire lower court argument. So it should have been under the 1-year limitation set forward for fraud.
But where this was resolved under subsection 5, which talks about equity, is it your contention that there needs to be some additional finding of wrongdoing, nefarious plot, I think you said?
Under Weitzman, yes, there has to be.
That may have been, if I can.
Yeah, go ahead.
And that may have been my question earlier, asked inartfully. Are you saying that Weitzman limits subsection B5 to only cases involving fraud or wrongdoing?
No, Weitzman is a strange case. I don't agree with Weitzman because it talks about the subsection 5 and it talks about fraud, but it also talks about victims and wrongdoers. And it's very unclear whether that entire opinion, the opinion is unclear whether it's based on the acquisition or it's based on the acquisition and the outcome, or if it's based on the acquisition and the misconduct and the outcome. So it's very unclear specifically what factors they relied on in that case to make that determination, because they say fraud throughout.
All right, Counsel, you're out of time.
I think this is, just to clarify, I think this is a fraud argument that should be limited to 1 year.
Thank you, sir.
Yep.
All right, thank you for the arguments.